Okay, welcome everybody. I am Rachel Kiesler. I am a family support coordinator for the Northwest and Southwest region for the Connecticut Family Support Network. And I'm very happy to be here with you all tonight and Attorney Lawrence Berliner. He is here to present tonight about basic special education laws. And Lawrence Berliner is the founder of the law office of Lawrence W. Berliner, LLC, which is a statewide Connecticut law firm with a concentration of special education and disability law. His practice is located in Westport and Guilford, Connecticut, although I think you've been working from home a lot lately, right, Lawrence?
This is my third office.
Yeah, your third office since COVID. And Lawrence has been in practice for 38 years, correct?
My daughter makes me feel old, 40, but I'll go with 38.
All right. Lawrence practices law in the areas of special education, disability law, and handles cases before various administrative laws, tribunals, and practices in the state and federal courts. He's also lectured extensively to special education schools, parent groups, and special needs organizations on issues affecting children or families with children with disabilities. He's also taught at Quinnipiac University School of Law and has published numerous articles on special education matters and the American with Disabilities Act. I'm very happy that you are here with us today, Lawrence. I thank you. We are going to have time at the end for questions, so please save them for the end. And then if you could all just stay muted so that we can all hear Lawrence for his presentation, we would really appreciate that. And I'm going to turn it over to Lawrence to begin. Thank you.
Well, thank you for having me, Rachel, and thank you for everybody who's participating, taking time out of your busy days and evenings to join this webinar. As Rachel pointed out, I am an attorney in the field of special education law. I practice exclusively in Connecticut, so all my comments are Connecticut-based. We're dealing with a national or federal special ed law, so all 50 states are bound by the federal special ed law requirements, but there are variations within each state on how the special ed law is administered and how the services are delivered. I have put a couple of items in the chat. The link to the ed.gov is the Federal Department of Education's website, and ct.gov is a link to the state of Connecticut, but you would click on letter E for Department of Agencies and you'll get a link to the State Department of Education's website. And then I also put a link to a recent publication that has a side-by-side comparison of the old IEP and the new IEP. And then finally, some top 10 strategies for transitioning back to the school year now that the beginning of the 22-23 school year has started. And I don't know about the audience, but I was receiving a lot of calls before the school year started and many more since the school year has started. So in the old days, when I would do these presentations in person, including presentations in the past to the Connecticut Family Support Network, who's hosting tonight's presentation, and I thank you for having me. I would ask for a show of hands, how many parents have children with IEPs, 504 plans, neither. But, oh, I see it. Okay, we do have a couple of hands going up. I see two, because that determines whether I should go backwards and start at the beginning or go forward and just pick up, with what parents already know. I know there are about 20 or so people, and I see several hands and thumbs up. So I'm just going to skip over or just quickly summarize the background when you have a child with an actual or suspected disability, we have a referral to special education. In Connecticut, we call them PPT meetings. Other states call them CSE meetings, IEP meetings. They're all the same meetings to discuss a child's needs as to whether or not they do or do not require special education. And evaluations are typically done by school districts, and reevaluations are typically done by the school districts as well. What I have found in a couple of recent cases is our parents are being denied evaluations or referrals to special education because the local school district is using SRBI, scientifically based research interventions, sometimes referred to as response to intervention. These are the regular education diversionary services that are sometimes provided to a child who is about to turn the corner. They're having some difficulties reading, but a little extra help once, twice, 3, 4 times a week, or they have some problems with math, and that helps them turn the corner. And they're back on track, approaching or actually on grade level. But what I have found is in a couple of very recent cases that RTI or SRBI was being used to delay an evaluation or deny a referral to special education. And the US Department of Education has been very, very clear since approximately 2011 that local school districts cannot use SRBI or RTI, as it's called in federal law, to delay an evaluation or deny a referral to special education. We have 14 categories of eligibility. There are 13 in federal law, and we have 14 in Connecticut because we have broken up learning disabilities into a general learning disability and a very specific one called dyslexia. And that was done several years ago with a groundswell of support from parents. So parents should recognize that when they coalesce around a particular issue, particularly at the General Assembly, they can be a very powerful force for change. What we're looking at for initial eligibility or redetermination of eligibility is whether a child has one of the 14 categories of disabilities, whether there's an adverse impact upon the child's education, whether the child would benefit from direct instruction, which are the goals and objectives in the IEP, and then we determine, what services, what goals are to be provided in the IEP. Sometimes a child has a disability, but they don't require the direct instruction. And some school districts will offer instead what's called a 504 plan, which is about reasonable accommodations. Maybe a child needs extra time, or they need to use a computer when everybody else is doing things manually, or the other way around, they're doing things manually because they can't be on the computer. Those are just simple examples. So sometimes a child doesn't need the direct instruction. The difference between the IEP is we have goals and objectives, and those goals and objectives are measurable. The school district has to report periodically on progress, and that is not part of a 504 plan. There are no goals, there's no reporting. So parents should understand the difference between a 504 plan and an IEP. Now, parents have rights, students have rights, and those are called the procedural safeguards. And that's a booklet. Make sure you have the most recent one. I think it was done about a year ago. And those are your rights. There are about 20 overall rights. The ones I tend to focus on are the rights to an independent evaluation and dispute resolution. Often by the time that a family has contacted me or gets to my office in person or online these days, there's and when parents don't feel they're being respected, or if they feel they're not being listened to, often that's when they seek out attorneys such as myself, advocates, sometimes, consultants like pediatricians, psychologists, psychiatrists, occupational therapists, physical therapists, speech and language pathologists, and the list goes on. What the IEP is supposed to do is provide what's called a free, appropriate public education. And sometimes that's referred to by the acronym FAPE, F-A-P-E. Free, appropriate public education means that the IEP is based upon the child's unique needs, not what's available in the school building. It's designed to produce meaningful educational progress, and it's supposed to be without cost. That's the free part, free, appropriate public education, without direct cost to the parents. There's nothing really free. And annually, we are supposed to review that IEP, and every 3 years, we have what's called a triennial evaluation, and an evaluation at that time will redetermine eligibility. And if the child continues to be eligible, we write another IEP. The State Department of Education has a requirement that an IEP not be more than 365 days old. So often I get calls, the school district is late in scheduling a PPT meeting, and the parents are told, we can't move back the date. And that unfortunately creates some unhealthy tensions between the family and the school district. So there are ways to get around that, but the date can't be moved. But sometimes we will have a mini PPT meeting. We'll just agree to extend the IEP for another month until we can have a PPT meeting. But this way the school is in compliance with the state requirements, and we don't have to rush to have a PPT meeting to satisfy an arbitrary requirement that an IEP not be more than 365 days old. Other rights that I focus on are the independent evaluation. If a school district completes an evaluation and the parents disagree with the evaluation, they have a right to an IEE, which is not an IEP, but an IEE that's publicly funded, unless they want to obtain their own at private expense. If the parents are requesting an IEE at public expense, the school district has two choices. They can say either yes, which means they'll pay for the evaluation if the evaluator meets the criteria for outside evaluation. So you need to know the school district's criteria. Or if the school says no, then the school has to file for a due process hearing against the parents to defend their evaluation. It's often advisable to speak to an attorney if you're in that situation where the school has filed for a due process hearing against the parents. And these are part and parcel of the procedural safeguards. Other procedural safeguards are dispute resolution, mediation, or going to a due process hearing. Most of the time, I file for a due process hearing to get a meeting called a resolution meeting. The resolution meeting is a settlement meeting where both sides try to work towards the middle. I don't mean 50-50. I just mean something in between what the parents want and what the school wants, and hopefully we can reach a consensus opinion and move forward. Now, I'm just going to make reference to the side-by-side comparison, which will come up on the screen momentarily. And you'll see this is available, this link, let's see. Yeah, this is a new publication from the State Department of Education. And what they're doing, you'll see on the left side of each page is the old IEP form, and the right side, the new IEP form. And over the next year, if it hasn't already happened for you or your child, you're going to see a merging of the old IEP, which is called the current IEP, and into the new IEP. And you'll see that there are changes. For example, on the two slides that are up here, you'll see NA is on the side, right side of the screen, because the format is different. So what's happening is the State Department of Education is the basic document hasn't changed, but how it's being handled, it's all electronic. And there are drop-down menus, which I'm not familiar with. I was telling Rachel, I was at a meeting earlier today with some other advocates, and we were, commiserating that basically we know so little about this because the training was provided primarily to the school districts. And then I found out from one of the advocates that the school districts are also struggling in understanding this new technology and this new format. So I don't want to give misinformation. I'd rather just say, here is the side-by-side comparison. There will be more to come. And right now, this evening, I'm just not prepared to get into it because I, for example, just learned about these drop-down menus, which don't show up clearly on this side-by-side comparison. So what's very important is for parents to ask questions. If it doesn't make sense, ask questions. Where is it I have a saying, if it's not in the IEP, it doesn't exist. So especially with this new format, parents should say, where is it in the IEP? Are we putting language that used to be in the prior written notice somewhere else? Are we putting language on evaluation procedures that were in the old IEP? Where is it in the new IEP? One advocate mentioned we have to put that kind of evaluation procedures into the language of the short-term objectives. I think it's a good suggestion, but how the school districts are going to be implementing this new IEP, it's still very much a work in process. The only thing that makes sense to me is you'll see this slide that I have right here. Those are the reasonable accommodations pages, and most of that is, carried forward on the right side. But when you get to the actual, let me see, goals and objectives, you'll see changes that may be confusing, and unless you know what to ask for, you may inadvertently allow information to be buried somewhere in the IEP. So if you don't see it or you don't understand it, make sure you ask. You'll see this slide right here where the cursor is. This is the current IEP, and in the middle here we have the evaluation procedures, and in the old IEP at the bottom of each page was a code, a letter code. We're going to use pre or post baseline data, teacher observation, work samples. There was a way to evaluate the goals. You don't see that here on the new IEP, but elsewhere, and it's not clear in this side-by-side comparison where it is. And the answer, it's in a drop-down menu. So unless you know where to look or what to ask for, you may not see it. Now, one of the major changes to the IEP format is there's a parent portal. And I haven't seen that yet, but parents should be able to access this document and any other information that there are two ways to put information in the parent portal. State Department of Education information like the IEP will be in the portal. Whatever else is in the portal, it's because the parents and the school district are putting that in the information. So what's supposed to happen and what's supposed to happen, whether it'll happen, only time will tell. There should be enhanced communication back and forth between the family and the school, and avoid some of the miscommunication and misunderstandings that have happened in the past. This is supposed to have an easier flow of information, but I myself, I've only dealt with two of these IEPs. One, it was all by agreement. We agreed to an out-of-district placement. And so I wasn't that concerned with the IEP. I was just more concerned if the private special ed school was meeting the child's needs. The next document is more about taking ownership as we're moving back to school. And I have, top 10 strategies. I'm going to put a, let's see, do we have that top 10 strategies? Yeah, it's right over. Here we go. Okay. I have my IT department to my immediate right, also known as my daughter, helping me with the technology piece. So some of this I've already covered, like item number 1, trying to understand the new IEP. The 504 plan hasn't changed. It's still the same. Does a child have a disability? Does a child have does a disability have an impact on the child's major life activities, such as learning, hearing, thinking, concentration, and what kind of accommodations does a child need we are providing in the 504 plan. But it's very important that you familiarize yourself with the IEP. It's very important you familiarize yourself with the lingo of the of special education. And I put a link on acronyms. A lot of times I'm as guilty of this, but I try not to be, as many other people are, to speak the lingo. Sometimes I tell parents, I don't talk this way. I call it psychobabble, but I'm talking the language going on. My favorite story was many years ago. I received on the acronym, that is, I had received a call. I don't remember if it was Thanksgiving or Christmas time. A parent called me in a panic that the teacher had called, and they want to give her child a rat, and it turned out that the class had a pet, which happened to be a rodent rat, but the rat that they were talking about was a WRAT, not the RAT, and that's a wide range achievement test. So had they bothered to explain that they were talking about WRAT, not RAT, that parent, wouldn't have gone into a panic, and she wouldn't have called me. But since she did, I now have a favorite story. What you need to do is, especially after the school year has started, I would say if you did it before the school year, I think we're stuck on one of the, yeah. You want to, whenever your last PPT meeting was, you want to make sure that everything's in place. Was equipment supposed to be purchased? Was training supposed to be acquired over the summer? In many cases, are the staff even there? I've read many stories, as I'm sure everybody else has, about staff shortages, resignations. The IEP says one thing, but the staff aren't there to deliver the IEP. Well, the IEP as written is supposed to be delivered. And it's up to the school district to hire the staff and figure out who's going to be there rather than ignore the IEP. So you want to, review the IEP, familiarize yourself with it, make sure that the services are being provided, make sure the staff is there. If there's equipment to be purchased, that was provided, that was acquired, training, whatever is necessary since your last IEP. If you're running into problems, you can always start at, at the informal level. Did you speak to the teacher? Did you speak to the principal? And if you feel that you're getting pushback or static or resistance from the school with respect to your concerns with your child's IEP, then, if the meeting doesn't produce the desired result, then that's where you start with the more formalized meetings, the PPT meetings. It's very important that you maintain a written record of your communications. I have a lot of parents say, well, I spoke to the teacher, I spoke to the principal. I don't doubt for a moment that conversation or that meeting occurred. It's just there's no written record. So if parents, I'm not telling parents to write, 4-page emails, but just, thank you for your time today discussing my child's IEP. Could you tell me when the speech and language pathologist will be, providing services? Because you as parents, it's important that you want to monitor your child's progress as parents at home. I always use a simple example. If the school is saying your child can read at school, you should be able to see that at home. If they understood a math concept at school, they should be able to generalize that to home and do their homework independently or with minimal support from the parents. Homework is for the child to reinforce a skill that was supposedly learned during school. It's not supposed to be a source of aggravation and angst for the parents, although often that's the case. If you have, if you're dealing with a level of anxiety, and even though some people have declared victory over the COVID-19 health emergency pandemic, I haven't seen the flag of surrender go up by the virus. So if you're dealing with anxiety related to COVID-19, you're dealing with loss of educational opportunity, which happened throughout Connecticut and all states during the past 2.5 years. There was a report that was just released talking about the level of lost educational opportunity throughout the nation. And it did not hit each state equally. And in Connecticut, it did not hit each school district equally. The State Department of Education just released a report, town by town, school district by school district, and how math and reading in particular scores were impacted. Some in a small way, some in a more measurable way. But I just gave an example. There was one school district that had a 4% decline in reading scores, and they were saying that, that was a major educational loss of educational opportunity because of COVID-19, online learning, anxiety. And I went to a nearby larger school district, and they had a 22 or 28% decline. So if one school district thought 4% loss of educational opportunity, that's the decline in test scores, the NWEA or the Smarter Balance, the statewide assessments. The point I'm trying to make is the pandemic has affected all children, all families, and there may be a lot of residual anxiety that is still out there. I will point out the governor had a press conference a few days ago talking about the mental health support funding that is being released. I think was in the neighborhood of $50 million. Congress has appropriated a lot of money to the states. That must be Connecticut's share of the billions of dollars with a B that Congress appropriated for mental health supports. How those mental health supports are going to be provided, the answer is I don't know. It varies from school district to school district. I apologize, there's a typo in here, but your transition to the 2021 should be 22-23 school year. So I just apologize for that typographical error on my part. Social skills are another area of concern. A lot of children with the online learning lost their, the day-to-day banter, being in school, being at the lunch table, going out for recess, just being with their peers and their classmates in the classroom. So these are things that are still out there, and you as the parents are the best person on earth to measure your child's progress, whether they're anxious, if you're dealing with school refusal, you're dealing with meltdowns after school, you have to pick your child up early from school. Those are red flags that you need to figure out what's going on. You want to make sure you're on the same wavelength with your child's teachers. I mean, this is supposed to be a team effort. This is supposed to be a collaborative effort between you and the school. I mean, we set up public schools to serve a societal purpose. We expect children to have their basic foundational skills met so they can be ready for each next step in their life. Each next step is preschool to elementary school to middle school to high school to life after high school, because this is the next generation that we are preparing to take their rightful place in society when they become young adults. So we want to make sure that they have all the basic foundational skills, the academic skills, the social skills, other skills that will allow them to be successful, go off to college, go to work, live independently, and not, I always use a cheese metaphor. You want them to look like a solid block of cheddar cheese, not a block of Swiss cheese with a lot of holes in it. And then lastly, because of this, we're still in this era of COVID-19. You have to be familiar with the mask mandates, the vaccination mandates, and I know this can be a source of angst and confusion. I've had some parents that are very concerned that their children are going to school without mask mandates. I have other parents that are concerned with the vaccines. So you need to figure out a way to work collaboratively with the school district, and rather than feel that you're being pushed into a corner or you're pushing them into a corner. As I mentioned, there's a lot of school-based anxiety related or unrelated to COVID-19. Make sure you understand what resources are available within the school psychologists, school social workers, school counselors, mental health supports. Some schools have school-based clinics. These are all, part and parcel of newer mandates, which are funded either through state or federal dollars. So that's sort of an overview of rights to a free, appropriate public education, how the lay of the land has changed because of COVID-19, what you're going to be dealing with going forward with the brief outline of the new IEP, and making sure you understand your procedural safeguards. So we had received some questions ahead of time, and I'm going to let Rachel handle that. And I'm here to answer questions as best I can and as time allows.
Sure. So we had a question: can I outplace my child, and what services can they have in school? That's kind of the last part of the question is kind of broad.
Well, we always start with the public school. Doesn't mean we end there, but we always start with the public school because children with disabilities are supposed to be educated in the least restrictive environment. Which means appropriate. In some cases, the public schools work out perfectly well. Let's see, I'm having an unstable internet. I don't know if that's on my end or yours, so let me know if it's freezing. In some cases, we have students doing quite well in public schools, and in some cases, not. When a student is being denied a free, appropriate public education, sometimes parents seek out alternatives to the public school placement. In other words, is the educational grass greener somewhere else? The State Department of Education has a list of approved private special ed schools, and there are about 80 or so schools in Connecticut. Some of them serve children with emotional disabilities, autism, learning disabilities, on and on. There's one that actually focuses on speech and language, communication difficulties. And so if you're seeking an out-of-district placement, either you're going to ask the school district through the PPT to make that placement. And if the school district denies that request, then sometimes parents make what's called a unilateral placement. So what that means is if a PPT makes the placement at an approved private special ed school, whatever is in the IEP is supposed to be delivered by the approved private special ed school. In effect, the school becomes an extension of the public school. When a parent makes a unilateral placement, that means outside of the PPT process, the services that are going to be delivered are what the parents and the private school work out together. The school does not have a mandate to serve children in private schools unless it's a PPT placement. Now, there is an exception, which is not what I'm talking about. There are sometimes parents will send their child to a parochial school or to a prep school, and they have some special needs, but they're not special ed needs. There is a way for school parents to ask the school district where to provide what's called equitable services, and it's a small amount of financial reimbursement. So if a child was struggling with handwriting, maybe the school would fund or provide funding for an occupational therapist. So it's not a lot, but most of the time parents are making a request for an out-of-district placement, or they're making a unilateral placement. And that's often where the dispute, which requires the procedural safeguards to be utilized. Can we come up with typically a financial solution in between 0 and 100% that works for both sides, or do we have to litigate who's right or wrong on what's called a denial of a free appropriate public education?
Thank you. Okay. Are there different levels of letter writing to the district, and should letters be drafted with each incident that occurs outside of the EEP? For example, seat belt restraint utilized that is not written into an IEP.
That's a very good question. First of all, if there's an incident, and I put that in quotes, there's supposed to be an incident report. So if a child is injured, or there's seclusion and restraint, or something that looks like seclusion and restraint, the school by state law is supposed to be reporting that to the parents, I think within 24 or 48 hours. They may make a verbal report, but they're supposed to follow up with a written report. As far as using seatbelts, that should be in the IEP, because just like the school building is supposed to be appropriate, as in a free appropriate public education, so is the transportation to and from school. The school district, if they're going to use a regular seatbelt and that's their policy, that's one thing. But if we're using harnesses or otherwise restraining the student on a bus, that should be part of a behavior support plan, a behavior intervention plan, a functional behavioral assessment. These are all concepts that are utilized to determine whether or not a child should be restrained in any way, whether it's in a building or on a school bus or a school-sponsored activity. Now, the letters, a lot of times parents write letters that are full of venom. They're very angry, and they should be. But I also remind parents, this is why erasers were originally invented. This is why whiteout was originally invented. And now we have the delete button or the editing button on our computers. It's probably very good to write your email, but don't send it until you calm down and edit it, because sometimes your words can be used against you by the school district. So I usually, it depends on the gravity of harm. If a teacher was absent for 3 days in a row and you didn't know there was a substitute teacher, that kind of email may be less, maybe more sanitized, less acrimony in the letter. But if your child was injured, secluded and restrained, and they come home emotionally wounded or physically, injured, that is going to generate a different kind of response from the parents. So it depends on what we're talking about: the IEP not being followed, the teacher being out, seclusion and restraints that you're not aware of, bullying, harassment. It depends on what the issue is and what kind of incident. So the answer is yes, there are different types of letters or emails that should be written. And as I said, they shouldn't be written when you're full of anger, and because you may end up regretting what you just sent. So if you can sleep on it or wait a couple hours before you send the email, edit it, and because I have seen those emails and letters being used against the parents, And in some cases, very extreme cases, it destroys communication and any goodwill between the school district and the family, or the family and the school district. So I guess you use your discretion on how to respond.
That's very good advice, because yes, they can go back and use it against you, unfortunately, or they don't end up taking you seriously after that because you've been emotional.
Well, that's a good point. I always tell my clients, you have a right to be passionate about your child, because if you're not, who is? And we are hardwired as parents. When somebody's hurting our child, we go into whatever mode we go in to protect our children. But once that has passed, there is a point we should calm down. And that's what I'm saying, is maybe that's the point the letter or the email should be written, not in the heat of passion.
Yeah. Somebody asked about if there's new laws or laws regarding a ratio of paraprofessionals to student support.
I'm not familiar with that. What I am familiar with is a lot of school districts are reporting a staff shortage. So if there is a ratio, it may be there. But what I also know is a lot of school districts have lost teachers for a variety of reasons, or paraprofessionals and other staff. So the answer is I don't know. I haven't heard of that, and I don't know the answer to that question.
Okay, thank you. Somebody else asked about rights for asking for an AAC device and training for a nonverbal children.
Excellent question. Parents need to be proactive in conveying their concerns for enhancing their child's education. And that's paraphrasing the law, the federal law. In anticipation, there is, I don't know if you can all see this, but there is a Connecticut Assistive Technology guideline booklet available on the State Department of Education website. And this goes through, in effect, an A to Z, what your rights are. And assistive technology typically is provided because there is a need. That need is identified typically through an evaluation, public school or private. There are private, what are called AT is the acronym, assistive technology. There are private AT providers. Most of the AT providers and evaluators are through the school districts or their consultants. And once we determine there's a need for assistive technology, that has to be plugged into the IEP to ensure the free, appropriate public education. Now, if you have a child who's nonverbal, and we are a verbal species, we talk a lot, we don't like to write. Writing is a more after acquired skill, but we've been using language since the dawn of time, as we've measured the dawn of time. And it's important that we have an ability to communicate in writing, verbally, technology. So the only specific mandate there for a child who's hearing impaired or deaf, there is a form for the language communication plan. But for everybody else, and it looks, this is also available on the State Department of Education website. It's called the Language and Communication Plan. And this is for children who are deaf or hearing impaired. As far as I'm concerned, there should be a language plan for anybody who has some limitations on their communication, but that's not how the law was written. So that's why the fallback position is becoming familiar. It's about a 250-page document, so I don't want to 250 pages, what was Attorney Berliner talking about? Again, it's very detailed, it's very comprehensive, how, what the school districts are supposed to do, how you're supposed to get it being the assistive technology, and it should be written into the IEP. In the old IEP, on page 8 which was the accommodations page, that's where the assistive technology would be listed. I don't know where it is on the new IEP, but if it's not listed, as I said before, if it's not in the IEP, it doesn't exist.
Thank you. Okay. When a student refuses school, do the parents have to worry about truancy?
Absolutely. I believe if there are 10 unexcused absences, unexcused, not excused, unexcused absences, the school may refer the family for truancy, possibly educational neglect. So if you know within a day or two why your child is not going to school, if it's 101 fever, that's an easy one. Just get a note from the pediatrician, please excuse my child from school because we're following school policy and we're supposed to keep them home. But if we're dealing with some kind of anxiety and social and emotional issues, school refusal, meltdowns before or during or after school, that may not lend itself to getting a pediatrician's letters excusing the absences. So parents have to be proactive and realize there are a finite number of days, I believe the number is 10 unexcused absences, before they themselves as the parent, forget the child for the moment, could get themselves in trouble. In other words, don't ignore the problem and expect it to go away. Now, if your child is refusing to go to school or they're coming home major meltdowns, that's the responsibility of the parent to do their best to figure out what's going on. Or if you're not the best person to debrief your child, find somebody who is, a relative, a pediatrician, a psychiatrist, psychologist, a therapist, somebody who might be involved with your child. Sometimes calling a best friend, you say, what happened at school today? And you might find out from that parent or the other student what happened in school today, especially sometimes students don't want to talk about it. They don't want their parents to know what happened. So that's what, so you do have to watch out for the unexcused absences and avoid that, to avoid educational neglect referrals or truancy referrals.
What about if it's related to, like, specifically to their disability? Is there, my first thought is like maybe getting documentation from specific doctors based on their disability. I don't know what your thoughts are, Lawrence.
Whoever is involved, with a child, a specialist, a generalist, like pediatricians are more generalists and there are specialists. The point is we have these mandatory school attendance laws in all 50 states, as far as I know. I'll just focus on Connecticut. And if your child doesn't go to school and they're supposed to be going to school, public or private, we as adults, their parents, can get ourselves into difficulty. So, wherever the source of information is, it can always start with a parent. Call the attendance line, send a follow-up email. My son or daughter is very upset and is unable to go to school today. And if that upsetness continues on for the next day or two, that's where the school might be asking you to get a letter or a note from the doctor or therapist, whoever's involved with your child. So it's what I said before, don't ignore the problem. It's not going to go away, and it may come back and haunt you in the form of a referral to for truancy or referral for educational neglect. Now, if your child doesn't have an IEP, that's where you can be proactive as a parent and ask for a referral to a PPT meeting to find out what's going on, because sometimes parents know exactly what's going on, and sometimes parents are the last to know what's going on. Most of the time it's in between. So parents are usually a very good source of information about reporting what's happening with their child. And if you can debrief your child and you understand what's going on at school that's making them upset, so they won't go to school, they have somatic complaints, they have school refusal, they have meltdowns, you have to pick them up early from school. something is going on. I mean, school is supposed to be an enjoyable experience, emphasize on the word supposed to be. Many times it is, and unfortunately, many times it's not. But I always put this in sort of adult terms. If you look at your child's job right now, what is their job right now? They're supposed to go to school. They're supposed to learn as much as possible. And going to work should be, a reasonably pleasant versus a very unpleasant experience. So if they're not happy at their place of employment, going to school, what's going on? The problem is this is a job that your child can either quit or get fired from. And that sometimes where the negative emotions come into play with meltdowns, school refusals, shutting down, picking up early from school, spending time in the school nurse's office because of headaches and stomach aches and other reasons why they don't want to be in class.
Right. Thank you. Just for clarification, the new IEP started this new school year, correct?
There's two answers to that, and that's yes and no.
Okay.
Every new IEP developed on or after July 1st, 2022, the answer is yes. But if you had an IEP developed before July 1st, 2022, the old one will be carried forward. So this next school year, the old IEPs will be merging into the new IEP. So if you have an annual review PPT meeting on October 1st, to review the 21-22 school year IEP, suddenly you're going to go from the old IEP to the new one. So the old IEPs are carried forward until the next annual review date during the 22-23 school year. The new IEPs are any ones that are developed on or after July 1st. However, I had a PPT meeting on July 12th over the summer after July 1st, and we never got the IEP. I followed up, and I followed up. Finally, last week or the week before, almost 2 months later, I get the IEP, but it was the old IEP format. So what I surmised was that school district didn't know how to figure out how to use the new technology, so they used the old one. So that's how that was my first inkling that maybe the school districts are not up to speed with this new IEP format, but that's what's supposed to happen as the old IEP is coming up for review during the 22-23 school year, and afterwards that old IEP format will disappear.
Right. Okay. That makes sense. We had another question about a parent was wondering if you're seeing, like, in the school community, if reactive attachment disorder is being, like, acknowledged at all.
Well, that's an interesting question. The answer is yes, in a generic sense. We do have 14 categories of eligibility, and one of the 14 categories is emotional disturbance, which under state law is now called emotional disability. It's the same term. It was just, I guess, changed. There was an act in the General Assembly to change emotional disturbance to emotional disability. And what an emotional disability is, could include a reactive attachment disorder. Is there a specific category of reactive attachment disorder? The answer is no, but it should fit into the emotional disturbance or emotional disability. If there is an adverse impact upon the child's education, and the child could benefit from an IEP. Sometimes there are some schools that are offering what is called trauma-informed therapy, but that's not universal. So, and I have had a couple of clients with a reactive attachment disorder as the formal clinical diagnosis. However, that was brought on by trauma very early in their life. And so even though they were much older, I think one was in middle school, I forget the other one, what happened was the school had to reach out and bring in, it was called trauma-informed or trauma-centered therapy, and that was part and parcel of the reactive attachment disorder. You won't see a box on the IEP that says reactive attachment disorder. You'll see autism, intellectual disabilities, orthopedic impairment, learning disabilities, emotional disturbance, emotional disability, on and on. But so what's supposed to happen is the child's condition, diagnosis, the impact on their education should fit into one of 14 boxes of categories of eligibility.
Thank you. We are just at about 8:02. I know we did start a few minutes late. There are a few more questions I have on the list, but I did want to see if there's anyone else that is actually here that had any questions that they wanted to ask Lawrence. I see Jamie's hand up. If you want to unmute, feel free.
Hi, thank you so much. I just emailed you actually, but this is perfect. So observations, do you know if there's anything within the IDEA or FERPA, or I don't know, I looked this other one up called ESSA about parent or anyone general observation from members of the community or a parent to observe a child in class? That's for or against it?
Well, there are a couple of answers to your question. FERPA deals with privacy, and that's often what the schools will cite as a reason to prevent parent observations. FERPA prevents school districts from disclosing confidential information about a child, their name, date of birth, home address, social security number, the fact that they do or don't have an IEP. Merely going into a classroom to observe your child, as far as I'm concerned, is every parent's right. However, with school security being what it is today, with COVID restrictions in the past couple of years, I don't know what they are today, what ends up happening is that becomes a source of tension. So what I try to tell parents is first find out what the visitation policy is at the school. And if they say anybody can come in for an hour every 45 minutes, whatever, then it's really the visitation policy that you're looking at. Now, where the observations, the more structured or clinical observations come into play is not just a parent going in and observing their child, but for example, with a learning disability, one of the many requirements to find a learning disability is an observation of the child. Now, if you have a private evaluator, your child is not learning or seems to be inattentive or behaviorally dysregulated, maybe somebody with a PhD or a BCBA or psychiatrist, a behaviorist can figure out through an observation what's going on, and it may require many observations. So it depends if we're talking about a clinical observation, a learning disability observation, or a parent observation. If it's a parent observation, find out what the school policy is on visitations, and that way you're exercising your right as anybody else who's allowed to come into the building. But again, with school security being what it is, layered onto that, the COVID-19 restrictions on anybody going into the building, it should be less of a problem this year than it has been in the past 2 school years, but it's still a problem.
Thank you.
Answers your question.
Yeah, I was thinking more BCBA than parent.
Well, what some of the requirements are, I'll put it in the context of an independent evaluation. If the school district's BCBA is allowed to do an observation, your private BCBA should be able to do the same observation. So it depends on who's observing, why you're asking for an observation, and ultimately what the purpose is. So the problem, any strange adult coming into a classroom upsets the apple cart. Why are you here? Are you looking at me? Or, the teacher wants to maintain control of the classroom, wants everybody eyes forward, paying attention, not looking at the back of the classroom. Who's that person? Or I had one case where we were in a school for a PPT meeting. We weren't there for an observation. And the classes were, this was an elementary school, the child walked by, his parents looking straight forward. He was just embarrassed that they were in the building. So we're just waiting to go into the conference room for the PPT meeting. He comes back about a minute or so with his hands on his hips. He's angry. What are you doing here? Why are you here? We weren't there for him. He didn't do anything wrong. We were there for a PPT meeting. Maybe the parents should have told him, you might run into us in school, just ignore us. But they weren't even in the classroom, and he was already upset that they were in the building. So I'm just using that as an example of how our presence as parents can upset the apple cart. And just a stranger coming in, a psychiatrist, psychologist, behaviorist coming into the classroom to observe, can also upset the culture, the apple cart. And that's why, I think you need to be judicious in making the request. You should have a right to go in and observe your child, is what I'm saying. But how that is exercised, you don't want to trade one problem for another set of problems.
Very true. Thank you. I do have one other one, but I think it should be a quick one. I was told by someone who went to one of these trainings for the IEP that they technically don't have to do minutes, or they don't have to do a meeting summary where it says NA. So if I wanted minutes, I was told that they could say no, the district could refuse. So if the district does refuse to do minutes and I say, okay, I'd like to record this meeting, is that something that has to be said before the PPT starts so they also can pull out their video, their recording device? Or can I say it right then and there and they can go get their device and I can start mine?
Question. According to the State Department of Education, not me, PPT minutes or summaries are, quote, optional. So what I tell parents, in the old IEP, page 2, at the top of the page, you see PPT recommendations. At the bottom half of the page, the PPT summary. And often that minimal or blank, or sometimes you have 2-3 page summaries. It varies from district to district. So what I tell parents is this: it is your absolute unqualified right to record the PPT meeting. And some school districts will do it for you, just like tonight's Zoom meeting or whatever format is being recorded. Some schools will say, we'll just record it and send you a copy of the meeting. But if you're going to record the meeting, as a courtesy, you should let them know ahead of time, send them an email the day of, the day before, said, I'd like to record the meeting. It is your right. Now, why it's a courtesy is Connecticut is what's called a consent state, which means both sides to a recording have to consent to the fact that it's being recorded. If there are no minutes or there are minutes, you have the recording. The minutes are accurate, they're not accurate, you have the recording to go back. I also point out that if you don't have to record the meeting, you don't have to if you're recording the meeting, you don't have to multitask by taking personal notes. You have the recording. So if you can't think, read, write, hear, process all at once, well, you take one of those off the table. I don't have to write anything down. I'm going to record the meeting. So that's why I tell parents, just let them know ahead of time you're recording as a courtesy. This way we don't have to get into we're a consent state or not a consent state. It's just that it's your right to record the meeting. Now, if the minutes are either inaccurate or incomplete, another thing I advise parents, you can send the school a request to amend the record of the meeting. I said this, it's not in the minutes. Where's my request for X? It's not in the minutes. So sometimes the minutes are a fair summary, sometimes they're not. And so parents should read the minutes. If you have a tape recording, video recording of the meeting, you can go back. It's not your memory, you have it. The one thing I point out is don't get into a shouting match, because the quality of the recording will be compromised, because often you have inaudible. You're unable to hear what's going on. You speak, they speak, you speak, back and forth.
Okay, thank you so much. I appreciate it.
Thank you. It looks like Karen has her hand raised. Do you have a question, Karen?
Is there time? I know we're running long.
Yeah, I think we have time for your question.
Thank you. So just at a high level, I've recently become the guardian of a grandchild who is in high school in special education with an IEP.
Mm-hmm.
So spent the last couple of years trying to understand everything at play and, just understand how the process works. But one of the things that I'm seeing now is like a stagnated education, and could be for multiple reasons. Particularly problematic is the grading. So in the IEP, it says modified grades based on IEP, which is very vague. So the grades come in, they look like you would expect, someone was doing well, and yet the level of education the levels that the child can demonstrate are very low. So is there something to ask for? Is there a more measurable, meaningful way to understand if there is any progress, what kind of progress, etc.? Because I find this modified grades based on IEP to be kind of meaningless when the kid's not performing at grade level.
Well, the very first thing you need to do is come up with a baseline and figure out what's going on. And against that baseline, which might be on prior school year records or evaluation reports, to see where we are, are we making progress? The progress is supposed to be measurable and meaningful and not trivial or non-existent. So I always use a simple example to illustrate meaningful educational progress. If your child is going to learn how to count from 1 to 10, and we start the school year knowing number 1 and 2, and we end the school year at number 8, that's meaningful progress. Even though we didn't master the goal of getting to 10, we've got pretty far along. End the school year knowing number 4. Well, the school is going to say, yeah, well, the student doubled their knowledge of numbers. I said, yeah, but the goal is 10, not doubling the knowledge. I share your concern with modified grades based upon the IEP. I have no idea what that means. Our children, whether they have IEPs or not, are supposed to be held to the Common Core standard or the local curriculum standard. We want a robust IEP. We want meaningful educational progress. Those are not my words. Those are the words from the United States Supreme Court in 2 separate decisions. One in 1982 talked about the meaningful progress, and one in 2017 talking about robust goals and objectives that are not producing trivial progress, but meaningful, measurable progress. So what a parent or a legal guardian is supposed to do, and the last few years haven't been the best for this statement, is in the month of June, you should be able to look back to the month of September and say, okay, this is where we started. We knew number 1 and 10, and we ended the school year at number 8 in my simple example. That's measurable, meaningful progress. If the student is inquiring, internalizing the skills, acquiring the skills, and generalizing the skills, that's another way to measure progress. But if, using your words of stagnation, if we keep seeing, number 4, year after year, there's nothing to boost the progress. Why are we repeating the same goals and objectives or similar goals and objectives that are not working? So this is where family or parental input is very important. If your ward, or whatever the name of your person, the legal term is a ward.
Yes.
I don't mean to be
No, the grandchild, but that's fine. Word is, I understand.
You know, find out what's going on. You know, if we're in high school and we're at the elementary school level, why is there that disconnect? If we're still at the elementary school level in high school year after year after year, what's going on? You know, is the
I mean, it could be that, you know, it's just the capability. And then what? You know, is it could be that. It could be that this is all the student can demonstrate within the context of being able to leave high school at graduation with a meaningful diploma. So then it's a matter of, well, what happens?
Well, unfortunately, the age of eligibility ends at 22, and literally students with IEPs are pushed off the cliff.
Mm-hmm.
That's when special ed eligibility ends. So unless they're eligible for BRS, Bureau of Rehab Services, eligible for DDS, Department of Developmental Services, or other state agency services for young adults, it falls upon you as the family or guardian to figure out what the next steps are. What's supposed to happen is, with any student, is we're preparing them for each next step in life. So if the student is supposed to go off to college, do they have the skills necessary to be successful in college? If they're going to go off to the world of work, do they have the skills necessary to be successful in a place of employment? If they're expected to live independently and navigate their community, do they have the skills necessary to go into a bank, a grocery store? Can they cook a meal? Do they know the difference between 211 and 911, et cetera, et cetera? These are skills that take a while to develop. Some it's a natural progression, and some it may never happen depending on the student. So where I often start, when a family retains me, I get records. I do an apples to apples comparison. You know, what was the last evaluation? What was the one 3 years before that, 3 years before that? And if I'm still seeing the same gaps, worse, seeing the gaps widen, I start asking questions. And typically for me, the answers start with either school district or private evaluations, depending on whatever the gap is. Is it an academic, social, vocational transition, wherever the gap is? And I try to get qualified evaluators. That's often where the independent evaluation comes into play, to see if I myself can get a finger on the pulse and figure out why the student is not making the progress that's expected. It could be they have a neurological issue, an intellectual disability, a physical limitation, a hearing impairment. I heard a story this morning at my meeting this morning that a child was in preschool and kindergarten and was inattentive, was not participating. And it turned out that the child had a vision impairment that no one bothered to look at. And I said, what? Don't they do hearing and vision screenings in kindergarten? You know, this is totally unacceptable in Connecticut in this modern age, that we don't even do a vision screening. That, you know, go to the school nurse's office, a hearing screening, go to the school nurse's office, and that's done. And if you don't pass the screening, they make a referral or recommendation, go see your ophthalmologist or an audiologist or whatever. So you as a legal guardian should be able to dig deep into the records and find out what the baseline is, try to do an apples to apples comparison and figure out why or when or where the wheels went off the track. And sometimes the students max out at a certain point in time, and working on the fine points of Shakespeare is not that important. But working on reading a menu or reading a walk and don't walk sign is critically important. Doing algebra 2 may not be relevant, but being able to go into a bank and manage a checking or debit card is critically important. Do they go into a store and leave a $20 bill on the counter and walk out, or they come out with the right change? Are they going with a $20 bill for a $40 purchase and don't know the difference between $20 and $40? So it really depends. And this is, if they're in high school, this is where the transition evaluations are critically important, because the transition planning process is supposed to be based upon the student's interests and preferences. The transition process is supposed to prepare the student for their post-secondary life in the field of education, employment, and if necessary, independent living. And so if you're dealing with a high school student, I would like to know, what are the skills, what's being worked on, and how is this transition page and the IEP goals preparing the student for life after high school. So
that starts, what age does that start? 15?
It's now 14.
14.
Yeah.
Yeah, and just a quick follow-up. Just one more thing, my guardianship is in place until 18. But you mentioned special education services being in place until 22. So I'm not sure how, that's just another thing, where I could go to get more information about that.
Well, the probate court has publications online, and probably the local court, you probably are the guardian of a minor child, and that ends at 18. After age 18, you might be a legal guardian of a person with an intellectual disability, if they have an intellectual disability, or you may be a conservator of the person if they have a disability other than intellectual disability. That's just how our laws were set up.
Okay.
So after, on the cusp of becoming 18, about 6 months before, you might want to get the forms necessary to see if it's an intellectual disability or a conservatorship, and to get whatever information you need and apply for it at that time.
Okay, thank you very much. Appreciate it.
Well, thank you. There was one question, I don't know if it was you, somebody asked about the probate court and the right to vote, and for a person with an intellectual disability. I did get that and wasn't asked, but I'll volunteer the answer. The probate court, if they've asked that question, has a form and a hearing on determining whether or not a person with an intellectual disability can vote in Connecticut. For other disabilities, the law presumes you're competent to do something unless the probate court, through a guardianship of a person with an intellectual disability or a conservatorship after age 18, that is, says you're not capable or competent. So if that question was not asked this evening, I volunteered that answer. Go to the probate. A lot of good information.
Thank you, Lawrence. I think we are going to stop here because it's about 8:25. Okay. So thank you for everybody that stuck it out and that came. And thank you, Lauren, so much. We appreciate you here at CTFSN for collaborating with us again and presenting this wonderful material that's very important for all parents with special needs children or children with disabilities to know. Because as you already mentioned, we have to be proactive for our children. So it's important for us to know this information and to be prepared. So we appreciate having you tonight, and thank you very much.
Well, thank you for having me. I look forward to coming back at a future date. And I hope tonight's information and the referrals will be helpful and useful to your members and those who have participated in tonight's meeting. So I want to thank you as well.
Yes, and I did put your contact information. I did put it in the chat again in case anybody missed it in the beginning. So it is in there for anybody that needs it. And I hope that everybody has a great night. Thank you so much.
Thank you.
Thank you.